Stephen Glam appears on behalf of the state. I appear for Assistant District Attorney Jim Griffin.
William Hotchkiss on behalf of Mr. Holmes, myself and Mr. Holmes.
All right, we're here for a final pre-trial on this matter. Is it ready for trial?
It is, Judge. However, our trial is set for Monday, which is not a day of court in session.
All right, well, we're going to give you another trial date, unfortunately. We'll do so.
Not, but Mr. Holmes is out of the
Another date.
The only other thing the defense request to be heard on is the justice point level supervision. Mr. Holmes is currently on level 5 and uses justice point once a week. He's been perfect meeting with them for months. I'm asking the court to reduce it to level 3 supervision, given one is compliance with justice point and two, sort of the uncertainty of when and how the custody trial actually goes.
I have no objection.
Court will reduce supervision level to level 3 supervision. All the terms of supervision. All right, that was the court's order in the matter. You might be able to go live on YouTube. Thank you. Okay, to the next one, please.
February 15th.
February 15th for trial.
That's fine.
Can I just ask, does the clerk have Team 5's charging cycle? Do you know when Team 5 is charging? I just want to make sure we don't set this during a charging week. Okay, let me see if I can. Well, maybe I have it in my computer. Okay, that's good. March 15th for trial? February 15th. Yeah, that's still fine. Thank you. That's
fine. Can we do the PM that day?
So next court date, January 21st, 1:30 final trial, February 15th, 8:30 jury trial.
And obviously, final pre-trial is 10 days before that, make sure we have any motion to eliminate. Have to file the date. Thank you very much.
Thank you.
I think you're on mute, so you can't.
did he reduce it to level 3? I forgot. Yeah.
Thank you.
I got you.
Are these microphones supposed to be on?
Yeah.
Is that yes or no?
Yeah, and then turn your sound off.
No, actually do the opposite, because I can hear you through Zoom, so turn your microphone off.
This is off.
Okay.
So I have to be careful what I say. because everything for instance, if
Well,
I
you
said
can
something like,
mute yourself between cases.
but I was just going to say something like how good it is to see Judge Baroni, and I can say it very quietly, and I think he can hear. I wish I knew.
I don't know. I'm taking care of this. I told Wall I would zoom in my stuff is 20 intros. Oh, it's closed over there. When I saw you, I thought it was happening. No, he's not in person. Really? I didn't know that. I don't have it down. I don't have it today now. It's an in-person day.
All right, the following state was Jackson versus Sylvan, Campbell, 20 CF 14-14, appearances, please.
Carl Hayes for the state. Good morning, Judge.
Good morning.
Attorney Richard L. Boss appears on behalf of Mr. Campbell, who will be here shortly.
I didn't see one filed, Judge.
No, I don't, it wasn't ordered in court to my knowledge. Yes, I saw that. That's incorrect. No.
No, Judge. Nobody wants one.
Yes.
Okay. Who's my officer? Gotcha. Okay, we're calling the state of Wisconsin versus Kevon Jason Parchman-Marbell. 20 CF 1712. Appearances, please.
Robert Myeroff appears for the defendant.
Okay, nice and loud, Mr. Glam. All right, we're here for a status. Mr. Myeroff, what do you want to do with this case?
I don't believe I have either discovery or an offer. I'd like to get both of them and then set it for another status.
All right, Mr. Glam, let's get that going for him. And you get the discovery out to him and whatever offer is going to be made. And you can do that to him within the next, before the Labor Day break, and then we'll set it accordingly thereafter. We'll set one more status for it, and then we'll either decide it's going to go to plea or to trial. September 9 in the AM. Does that work
All
for
right.
everybody?
Yeah, wait, I'm looking at that. Just a minute. Yeah, that's fine with Myra.
Okay. Is that okay with the state? Okay, make sure they get on top of the discovery and offer on that thing so that. I'm not muted. Maybe I don't have that on, but most times they tell me to turn this on. All right, we'll see. I need to have the state make an offer and also to get discovery out to Myeroff forthwith. We have it scheduled for September 9th at 9 a.m. for status. So if you get it out next couple of days, and have a nice talk with Miss Brown, because you've been running into this with more than this case. All right, I appreciate that. Thank you very
Okay.
much.
Thank you.
Next, Matt. Okay, here we go. All right, now we're calling the case of State of Wisconsin versus Sylvan P. Campbell, 20 CF 1414. Appearances, please.
Good morning, Your Honor. Defendant appears in person by Attorney Richard L. Boss.
All right, gentlemen, we are here for sentencing in this matter. According to my notes, he's pled to battery by prisoner, which is count 2 of the information. I believe count 1 was to be dismissed but read in. Is that correct?
Yes.
Okay. And if I could have what the recommendation was, please, because I wasn't here on that date.
Yes, Judge, the state agreed to recommend 18 months of initial confinement followed by 30 months of extended supervision to be served consecutive to any other sentence.
All right. Any other conditions of extended supervision?
No, I would leave that all to the sound discretion of Your Honor. Further, I'd note that we have no victim impact statement to submit to the court, nor any request for restitution. I'd ask that the court set restitution at 0.
All right. All right. Is there anything else then you want to say in behalf of the state in terms of your argument of why that sentence is appropriate?
Yes, Judge. The defendant, Mr. Campbell, was, I believe, either on a hold or serving a revocation sentence at the secure detention facility across the street back in January of this year. His cellmate was a man named Bird Kong. Bird is B-I-R-D, Kong is K-O-N-G. At the time, Mr. Kong was 33 years old. A dispute arose between the defendant and his cellmate, Mr. Kong, and as a result, the defendant, Mr. Campbell, punched Mr. Kong, and then Mr. Kong fell to the floor of the cell, and then the defendant proceeded to kick and stomp on Mr. Kong. This incident was captured on video. And I just want the court to be aware that this isn't a one-punch affair. The video clearly shows that the attack was sustained. Now, the injuries to Mr. Kong were quite severe. He was rushed to the hospital and underwent emergency surgery. He was in a coma for approximately 2 months. He had to have a portion of his skull removed to alleviate the swelling on his brain. When he recovered his health and was able to speak to the investigating officers, he had no memory of the attack. He remembered being held as a prisoner at the secure detention facility, but had no memory of who his cellmate had been or how he had ended up in the hospital. The severity of the injuries alone merit a prison term in the state's estimation. I'd further note that these cases of prisoner violence are aggravated in the state's view. Mr. Kong and Mr. Campbell were both where they were to serve sentences that had been ordered by courts of law and to pay their debts to society. But nobody who's a prisoner in any correctional facility deserves to be attacked and viciously stomped and kicked, which is what the defendant did to Mr. Kong. The prior record consists of, he's got an open misdemeanor battery case, I believe. I'm not sure if that case has been disposed of yet. It's, last I checked, it was calendared for a trial. He was convicted of operating a motor vehicle without the consent of the owner in 2019. Judge Hansher sentenced him to 3.5 years in prison, stayed for 3 years of probation. In 2018, he was convicted of felony resisting an officer causing substantial bodily harm. In that case, he was sentenced to 3 years prison, stayed for 3 years of probation. In 2018, he was prosecuted for criminal damage to property. That case was dismissed but read in. As a juvenile, he was adjudicated for battery in 2018, and in two separate 2017 juvenile actions, he was adjudicated both for being a passenger in a stolen car and burglary. So that's the extent of the criminal history there. I think that the state's recommendation is appropriate, given the severity of the injuries. This isn't a self-defense case. Mr. Kong posed no threat to the defendant. This was just simply violence born of anger and frustration. And I'd ask that the court impose the prison sentence to be served consecutive to anything else. Thank you.
All right, thank you. All right, Mr. Voss?
Thank you, Your Honor. I have to say that I differ somewhat with Mr. Hayes regarding what happened here. According to my recollection, when I viewed the videotape, there was a argument between the cellmates, and they both engaged in mutual combat. There was an exchange of fisticuffs. Mr. Kong fell to the floor, and I don't remember seeing any stomping or kicking at all. He was being punched with his fist and so on. Our interpretation, Judge, and our belief is that what happened is it's shown on the video that Mr. Kong fell suddenly to the floor. We believe he cracked his skull on the cement floor or on a plumbing fixture, and that's how he got his cracked skull. Because what the film clearly depicts is both were engaged in a fist fight of a typical nature between two fairly equal men, which they're not supposed to fight when they're in jail anyway. But there was a mutual combat. He fell to the floor. We believe he cracked his skull when his head hit the floor, and my client did punch him with his fists. But we don't believe that the severe injury was caused by Mr. Campbell directly by punching him and so forth. He did fall to the floor, and that's where we believe the injury occurred. Certainly, Mr. Campbell did not intend to cause such serious damage, which is not an element of the offense, of course, but he did engage wrongfully in a battery, and that indirectly resulted in a serious injury to Mr. Kong, who we are hoping and trust has fully recovered. Now, my client does have a history. I can say that he was 18 years old at the time. He's 19 years old now. He has 10 grades of school. He has had a lot of problems in his life. He has one child, a year old. He has some problems with, he has been diagnosed with bipolar. He's taking Geodone, G-E-O-D-O-N-E, and another medication that I can't even spell. I'm going to say it's acetylene, and I have no idea how it's spelled. So that's the best I can do. Therefore, his bipolar, his Geodone, and anxiety medication he's taking as well. So he has a number of problems that he's been dealing with and struggling with through his life. He did serve his revocation that he was in MSDF 4. He's completed that. And so he is now presently, from that previous case, I believe the Amwa case, he is on ES right now. We believe that the sentence that's recommended by the state is fair. My client's taking responsibility. There's no defense really against this crime. And it was just stupidity, basically. And these two individuals were mutually fighting each other. And we believe that the serious injury that was not intended resulted from the fracas that took place at MSDF. My client would like to address the court.
All right, Mr. Campbell. Bring that microphone closer to him. Okay. Go ahead, sir. Nice and loud. You may speak your mind. Well, you know, I don't know how you get yourself involved with these things, but it appears just based on your record. And now what happened in this case, you have kind of a short fuse. Eric? Well, obviously that's what you're going to have to start working on. I mean, you know, nothing in this world is a straight line necessarily. Yeah, there's going to be frustrations for you, for everybody else. Doesn't give you a right to start beating the heck out of somebody because that's the shortcut to where you want to be, or you think that's going to be appropriate because for whatever reason, I sometimes I just simply don't understand how you get to these great thoughts when it turns out to be that a man is hurt, and especially to this extent. Now, you may not have initially thought that you wanted to intentionally hurt him, but obviously your continued activity would supersede that and indicate, yeah, you did try to hurt him. And it was your intent to go from there. Now, whether the first punch was involved in that fashion or you felt you were simply involved in a mutual situation, I wasn't there, nor was Mr. Voss. But clearly, what you did here was way beyond the call of any reasonableness with respect to how you want to deal with people, especially people who are mutually perhaps as anxious as you are and somewhat depressed about it, and on and on and on. But short fuses will get you nowhere but in trouble. Court has to consider that. I have to consider your overall mental health situation as well as the need to punish you for what you've done here, because this is a very egregious type of matter, and you're going to find yourself if you're, especially if you're dealing with a group of guys that are in any kind of prison setting, you're going to have to be very careful that you know you're going to do something like this to the wrong guy, and you're going to end up being in Mr. Kong's position. Not that we want that either, but I mean it's just the way you're going to have to just learn how to count to 100 before you start losing it, and go from there. So the court has to consider the certainly the egregiousness of this offense. I have to consider how I can deter you and others from doing it, while punishing you sufficiently in order to protect society, and hopefully rehabilitate you all at the same time. Bearing all those factors and considerations in mind, the court feels that 48 months in the state prison is appropriate, with that broken up 18 months initial phase of incarceration, followed by 30 months of extended supervision. While you're on it, and that's consecutive, by the way, to any other incarceration you're given in this or any other matter. I will tell you that during your ES period, and whatever happens at the prison, that's up to them. But during your ES, certainly the court would like to have a mental health evaluation, and for you to follow whatever medication regimen is dictated for you in terms of keeping you on a level playing field. I also want you to have an anger management type of counseling, so you should know how to count to 5, 10, or 100 before you lose it and hurt another human being. I want you to also note that restitution is going to be placed at 0 unless something changes within 60 days. We still have jurisdiction for within 60 days of today's date, but as of right now, it's set at 0. I'm going to also order that you have no contact with Bird Kong If he is in the state prison system, the court will order that you go to a different particular setting for your stay in the state prison. I will also order that you give a DNA sample of your body and that you pay the surcharges for that. I'm going to order that you pay the costs and disbursements of this action. All those things I've ordered to be paid shall be taken out of prison wages to the extent of a wage assignment of 25 up to 25%, and then payable on ES for any balance remaining due. Any balance due at the end of the ES period shall be converted to a civil judgment under the circumstances of this court's order. The court will tell you have 20 days from this date to pursue any post-conviction relief that you care to. If you do, so be it. If you don't, that's your choice. But you could be waiving some valuable rights. Mr. Voss is to go over that with you. Make sure you understand those, and then certainly file the appropriate documentation. Now, you're a young man, and ordinarily you certainly would be eligible for CIP, but because of your mental health situation, and I'm not the selecting authority as to who goes in that, they are. I will say that you're eligible for CIP, but whether you get selected because of your mental health issues, I can't tell you that. They're going to make you eligible. As far as the AODA assessment is concerned, all your situations I don't see there's an AODA problem. Maybe there's a medication problem that you're not following, but that's not an AODA problem. So I'm not going to find you eligible for a AODA program in the nature of a earned release program for that. The court will also tell you here today then all the credits you have, I trust, are being taken on your revoked case or on your other cases, this case being consecutive to that. I don't think there's any new periods of incarceration strictly dedicated to this case, is there?
Yes, there is. I have the form filled out that I'll be filing later with the court that we would ask for 127 days from the day of his initial appearance. He's been held, I believe, only on this case.
Only on this case?
See, he completed his sentence when? April. And since then, he's been held on this case.
Okay. So April 21 to today. I come up with 129.
That's fine.
I know that regardless, I'll let them calculate, but it's from April 21st, according to counsel, that he finished his other sentence. If that be the case and he's being held on this case alone, he gets credit for that period of time. That goes against his incarceration phase at the state prison. I will tell you that part of your stay in the state prison right now, you're obviously getting incarceration, but you also have this ES component. Understand that ES can be converted to in time if you don't follow the rules in the prison, if you file frivolous lawsuits, and should you be given requisite types of penalties of extended stay, which shortens the ES time and increases the incarceration time. Obviously, follow the rules, be a good prisoner, if you will, and hopefully you'll get out based upon what the court has ordered initially in this matter. All that being said, I will wish you good luck, sir. I will remand at this time.
Thank you, Judge.
Okay, you bet. I think he's going to file a form, but it should. I come up with 129 from April 21st to today's date.
And then programming, did he qualify?
He qualifies for CIP, but he may not be selected because of his mental health problems.
We call the case with somebody, just tell me.
Okay, ask her. She'll know. What well, that was on state versus Parchman-Marbell. Okay, I got you. Thank you.
November 15th.
Who do we have ready? Okay, I'm going to admit Daryl Smith right now. All right, and that's an Andrade. Is that Andrade?
Yeah.
Okay. Calling State of Wisconsin versus Allison Andrade, 20 CF 2186. State of Wisconsin versus Allison Andrade. Another case, State of Wisconsin versus Allison Andrade, 19 CF 3404. Appearances, please.
Stephen Glam appears on behalf of the state.
Daryl Smith appearing on behalf of Miss Andrade.
Good morning, Mr. Smith. Sorry we didn't get to you yesterday. We were trying hard, I can tell you.
No problem, Judge.
All right, thank you. All right, what are we doing with this case, Mr. Smith?
Judge, the newest case just caught up with the older case, so we have to regroup, come up with an offer, and then proceed from there. Then I'm still gathering the rest of the discovery to get to my client as well. And then she's got a case in Judge Wagner's, so it's possible that everything can be packaged. I just don't know yet. We gotta have a meeting of the minds and get an offer from Mr. Griffin.
What is the case before, what's the number of the case before Judge Wagner?
Judge, I don't have that case number on me. I don't have all of the files with me, but that case is gonna definitely be resolved. We were gonna plea on last court date, but when the new case popped up, I thought it'd be better to just see if we can get everything, at least a package offer.
I understand. All right.
I'll stay in touch with Mr. Griffin and I'll make a proposal to him.
All right, that's good. All right, well, let's go ahead and get this baby back on track. I think Griffin is off through the Labor Day holiday, if I'm not mistaken.
Yeah.
Okay.
I'll
Sure.
email
It's certainly hard to keep track of him.
It is hard to keep track.
And
But more important,
did I understand?
more importantly,
Oh, I was just going to ask, did I understand that Mr. Smith needs an offer letter and the discovery?
yes.
I think I may have all the discovery, but I'm not sure. I got to recheck my file.
All right.
But I'll email Mr. Griffin a proposal, and then we'll see. Hopefully we can come up with something.
All right, well, that's fair. Well, I mean, I don't know which court you're going to do it in. If the oldest case is in this court, generally
Right.
speaking, it follows the oldest case. And if that be the case, you could advise Judge Wagner that we'd be willing to accept the other case for
That's
us.
fine.
If you
That's
guys
fine.
decide the other way, we are
Sure.
begrudgingly willing to give up our cases to Judge Wagner.
Okay.
That being said, all right, let's go ahead. I would say it's probably going to take at least a couple weeks before you get everything and then have a chance to analyze it and get into it. I would say this one needs 30 days.
That's fair.
Yeah, I don't know. I was going to ask about that myself.
All right, you're going to ask about what, sir?
I was wondering, did the defendant appear yesterday?
No, she's on Zoom waiting right now. She got her court dates mixed up, but I'm in touch. I got an email her. I talked to her this morning.
Is she on the iPhone right now?
She may be. I don't know. I gave her all the Zoom information, but I'm in contact with her. I got her text right now.
Hello?
Is this?
Hello. Hi, what is your name, sir?
My name is Lawrence McClendon.
Oh,
That's not my case.
Not this case. Well, here's the deal. I mean, I'll be honest, I don't know about yesterday or today, but I'm going to issue a bench warrant for jurisdictional continuity, and I'll stay it until the next court date.
Okay.
Thank you. All right, Madam Clerk, 30 days roughly. No, it's going to be status. It's also going to probably incorporate a third case which we don't have yet. October 5th at 8:30.
October 5th at 8:30 is fine.
It's good.
Thank
Yes.
you.
Okay, very good. That'll be the date then for status on these two, and maybe even the third one, once you guys hopefully have a global recommendation ready under the circumstances here, okay?
Sounds
Thank
good.
you
Have a
again.
good weekend.
You too. All right, what do we got here now?
I'm also ready on a request for.
Now, Mr. McClendon's on the line too. Let's call that one. He's on the line, otherwise we'll lose him. State of Wisconsin. That's on page 4, bottom. State of Wisconsin versus Lawrence McClendon Jr., 19 CF 4487. I will.
There was this Mr. McClendon's case?
Yeah, that's what we're going to do. It's the bottom of page 4.
Okay.
Then we just asked for Domas to join us. Okay. Okay, Mr. Domas, good morning. Mr. Domas, unmute.
Hi, Judge. How are you?
Hi, just fine. How are you? We're calling the McClendon case. I just called it on the record. I thought I had you in, but I didn't. But I just called the case on the record. Mr. McClendon does appear on the Zoom line as well. And we have the state of Wisconsin then versus Lawrence McClendon, 19 CF 4487. Appearances, please.
Stephen Glam appears on behalf of the state for Assistant District Attorney Jim Griffin.
Attorney Joseph Domask appears on behalf of the defendant by Zoom video conference. Mr. McClendon also does appear by Zoom video conference. Good morning.
Good morning. We had this thing set for a plea today. What are we doing, Mr. Domask?
Judge, we had continued negotiations with the state. Ultimately, we've not come to an agreement with the state to resolve this, and we'd ask for a final pretrial and trial date.
All right. Give him a trial date, final pretrial date. He's out of custody.
Mr. Attorney Glam, I had separate from this case, I had emailed you on Mr. Hughes. If you wouldn't mind giving me a phone call some point today, I'll email you my phone number again.
Okay. Mr. Domas, to be quite upfront with you, I'm in court. It's my first day trying to do court without paper files.
Okay.
And I doubt very much that I will have time to call you today. Just an old man trying to learn new tech.
All right. Well, as soon as you can.
Why don't you send me an email on Monday to remind me, and I'll call you when I'm not quite so stressed.
Perfect.
What date is your trial? Christina, can you come up with We need a trial date. February 25th. Trial. How's that work for y'all?
That's good for the state.
What about you there, Mr. Domas?
Did you say February 25th?
Yes, I know.
I have that as a Thursday.
Well, February 22nd.
Sure.
Okay, that's good for the defense. What about the state?
It's fine.
All right, final pre-trial. About 30 days sometime.
That's good for the state.
January what?
21st. AM or PM?
AM's fine here.
You just say, what time did you say, the 21st? Okay, very good. Also, 10 days before the final pre-trial, people, get any witness list to me that you wish, any final jury instruction, and any motions to eliminate, and hopefully, discuss the motion to eliminate, we'll make the rulings on the final pre-trial date for any of those stipulated to. All right, thank you very much. Be stipulated to. All right, thank you very much.
Thanks. Good to see you, Judge. Take care.
You too. You too. Mr. McClendon, you may hang up, sir.
Thank you. Have a nice day.
You too.
Attorney for Joe is asking about adjournment.
What's his client's name? Thank you.
I assume you're calling that.
Hang on, I'm looking at Knack, Peter Knack. Okay, we're calling the state of Wisconsin versus Peter Knack, 20 CF 0326. Appearances, please.
Stephen Glam appears on behalf of the state for Assistant DA Jim Griffin.
Your Honor, good morning. Peter Knack in person and by counsel, David Bordeaux.
All right, we're here for a pre-sentencing matter. I do have the, we have a preset PSI in this case. I'm sorry, let me see. Okay, thank you. I'll check that out. I think you forgetting that to me. All right, we're here for a plea and sentencing. Have you filed all the documents?
Sir, I have not, due to the fact that Justice Point is not filed its latest report, and my client has finished treatment, and I do not yet have paper proof. I just need 1 or 2 weeks with Mr. Knack. He's out since December. He's had no violations. And unfortunately, in June, my office had a fire, so I've been displaced this summer. And that also contributed to the lingering difficulties in the case. All I need is about 2 weeks.
All right, what can we do for him, Madam Clerk, for a plea and sentencing in 2 weeks? Nothing. Okay.
Well, the soonest practicable date. How about that? At the same time, my client is ready, needs to get its affairs in order, and currently furloughed, so possibly that would affect the sentencing as well.
Well, we only have so many dates in September that we are up, I guess, and we'll just try to fit you in as best we can, but without having, yesterday we had 80 cases here.
Oh,
running about straight. So, you know, there's no sense trying to jam the calendar and put the number over to the next day and screws up everybody. So let me tell you.
I apologize, Madam Clerk.
Thank you.
I mean, we could try the morning of September 9th.
That's fine.
That is in person, correct?
So we'll say 9:30.
Excellent, and I thank the court.
September 9, 9:34.
I'll file the documents.
Get your papers filed so that we have them in advance, and then we'll go from there.
Thank you, sir.
All right, and that's in this room, I guess, is where they're gonna have it, so. We'll see you back here on the 9th. I will be here.
All right, excellent.
All right, you bet.
Thank you again.
You bet.
Thank you, you too.
All right, the next one is a Colin Eichler. Next case will be Colin Eichler. And he's appearing on page 4 of 9. Mr. Eichler's case is 19 CF 5065, State of Wisconsin versus Colin Eichler. Appearances, please.
Stephen Graham appears on behalf of the state.
Attorney Thomas Alberti appears with Mr. Colin Eichler, both in person. Good morning, Your Honor.
Speak up right into the microphone. We can hardly hear you. The microphone will bite you.
Can you hear me?
Better, but still speak up.
Attorney Thomas Alberti appears with Mr. Colin Eichler in person. Good morning. Happy Friday, Your Honor.
Better. Thank you. All right. Has there been negotiations in this matter?
Yes, we have a resolution.
Okay. State, give me what was the negotiations.
Sure, let me just find that. Here we go. I don't know if that helps the offer date. Yeah, I think that may be it. All right. Upon a plea of guilty to the charged offenses, the state will recommend the court impose full restitution for all victims, joint and several. The victim's deductible and insurance company would be included in that. The offer is contingent upon the victims being made whole within 30 to 60 days. The state will move to amend two counts of the misdemeanor theft. State moves to amend this. Oh, apparently we're going to amend this 2 counts of misdemeanor theft, and we'll recommend 1.5 years stayed for 2 years of probation with conditions of probation to include 30 days at the House of Correction time. I'm sorry for the disjointed presentation of this.
Well, do you have, let me ask you this, do you have an amended information changing it from operating the vehicle without owner's consent as a party to a crime in counts 1 and counts 2 to a misdemeanor theft information charging now the amended counts?
Let me just
not go ahead and generate one and get it to my clerk.
Mr. Alberti, do we know what the 2 misdemeanor charges were going to be?
Theft.
I got the statute.
Misdemeanor theft?
I got the statute on the plea questionnaire.
Okay.
It should be pursuant to section 943.20 sub 3. Count 1 and count 2 are both under that subheading. Probably be 939.50 maybe too.
I'm sorry, what was the misdemeanor? 943.
Point 20 sub 3. Should note it was also charged as a party to a crime under 939.05.
Thank you.
Both counts.
Hi, this is your lawyer, Sarah. Good, sorry, I've been calling the wrong number and I was like, oh, maybe I should look at this.
Will do.
Okay.
You there yet?
We're getting close. Can anyone tell me what the counts are in the current document?
They're both the same.
No, I know. I mean, are they count 1 and count 2?
Yes.
Okay, thank you.
And the first event occurred at 1109 North Cass Street. Second occurrence, count 2, occurred allegedly at 1024 East State Street. Same date of November 10th.
For the incident at 1024 East State Street, who is the victim, please?
They don't have it.
By initial? Does it?
They don't have initials in there, but I'll have to look at the criminal complaint. I'll tell you in a second, I guess. 1109 North Cass Street, it's DMH. And at the one on East State Street is that is AAN. AAN.
Okay. That should be open now. All right. I have generated one. I have signed it. I can't send it to CCAP because it wants me to select a court case. I can't just type that in.
Well, send it to me and we'll make a record of it.
All right.
We'll scan it when we get it, okay?
Where is it? Shall I send it to the clerk?
Yep.
Is that C. Tom's? TOMS. Oh, I got it right here, popped right up. It is on its way. Mr. Alberti, would you like to look at it over my shoulder?
Sure.
Hopefully I have all of this right. 10:24 with 8 a.m. at East State and 11:09 Camps.
Yeah, looks good. Thanks.
All right, I received the amended information. This is actually the fourth amended information in this case for the record. And the state is moving to amend the charges from that of operating a motor vehicle without owner's consent as a party to a crime in both counts 1 and 2 to individual counts of theft value not exceeding $2,500 as a party to a crime in count 1 and count 2. Now, you've had a chance to review this amended information, and Mr. Alberti, and you waive it for reading in open court.
Yes, Your Honor.
And are making a plea of not guilty until such time as the court accepts a guilty plea.
Yes, Your Honor.
Court will note that for the record and will place the amended information. Actually, this is the fourth amended information, as I mentioned, and that the court will accept the state's motion to amend. Sir, we are now before this court. We now have the offense of theft, value not exceeding $2,500 as a party to a crime, as the charges in count 1, and a separate theft value not exceeding $2,500 party to a crime in count 2. Upon conviction of each of these matters, the maximum penalty is a fine of not more than $10,000 or imprisonment for not more than 9 months or both. Do you understand each of the charges against you and the maximum penalties that could be given to you upon conviction of those charges? Speak up nice and loud. I know you're a lot stronger than that. Thank you. And you've heard what the DA has indicated to the court is the state's recommendation. Is that what you understand to be the recommendation in this case? Mr. Alberti, is that what you understand, sir, to be the recommendation in this case?
Yes.
All right. I want you to understand, Mr. Eichler, that even though the state has given this court a certain recommendation, I am not bound by their recommendation. I certainly will consider it. I'll consider what you and Mr. Alberti have to say. Bottom line, however, it's up to this court to give you whatever it feels to be the appropriate sentence, up to the maximums on each count that I just went over with you. Do you understand that, sir? Do you also understand that if you are not a citizen of this country and upon a finding of guilt by this court for either or both of the counts now before it, that you could be deported, denied admission, or denied naturalization to this country should the federal law be applicable in your particular circumstances? Do you understand that as well? Yes, I do. You also understand that in order for the state to prevail in this case, they must be in a position to prove up their case beyond a reasonable doubt. And they do so by proving up elements of the offense to which you're pleading to here today. As Mr. Alberti gone over with you and explained to you the elements they would have to prove up on each of these counts now before this court. And did you understand those counts as he explained them to you? Let's go over and apply those factual aspects to the particular charge. As to count 1, you would have to prove then that you did on November 10th, 2019 at 1109 North Cass Street in the city and county of Milwaukee, state of Wisconsin, that you as a party to a crime, that is, a person who aided and abetted the commission of a crime, did intentionally remove a major part of a vehicle, in this case, a catalytic converter, without the consent of the owner, a DMH, I believe, yes, and contrary to section 943.23 sub 5, section 939.50 sub 3 sub I, and section 939.05 of the Wisconsin statutes. Do you understand, sir, then, the elements the state would have to prove out beyond a reasonable doubt in this particular matter. In count 2, being charged with theft as party to a crime. There, the state would have to prove that you did it on November 10th, 2019 at, actually, at the dates juxtaposition on the counts, but count 1 is actually supposed to have been the Cass Street, but in count 2 is the East State Street, but the way it's set up right now, count 1 is East State Street and count 2 is North Cass Street, but I'll accept that because it really doesn't make a whole lot of difference with respect to the elements that would have to be proved up under the circumstances here. But understand that this second count concerns the one at 1024 East State Street, and it concerns that you, again, as a party to a crime, did intentionally take and carry away movable property of AAN, not VHB, unless I picked up the wrong count on that. Is there were 4 counts initially, and there were 2 guys involved. The guy 1024 1109 North Cass Street, VHB. I just looked at counts 1 and 2 of the initial complaint, but there were 4 counts. I probably should have looked at them all. Let me look at them one more time.
Okay, the count where AAN is the victim occurred at 1024 East State Street.
That's right. You have VHB as the victim.
Okay, then
But I don't know if I think that you meant to put down the correct one here, but let me just double check on the original complaint.
I've checked it against the criminal complaint.
Okay. So you got these juxtaposing. That's the reason. It's not making it more easier for us. So
I can attempt to do another.
No. Just so there's no mistake about it, the victim on 1109 North Cass Street is initials DMH. The victim on 1024 East State Street is AAN. Do I have your permission to correct those particular matters?
Please.
Thank you. And that there are the exact same other elements as there were in the first one I went over with you. And do you understand the charge against you then in count 2 concerning the matter at 1109 North Cass Street? And you had a chance to discuss each of these cases thoroughly with your attorney. And do you understand all the possible defenses, strategies, or tactics that might be utilized to defend against each count out before this court? Based upon all those factors and considerations, then, sir, what is your plea to the amended count 1 of theft as a party to a crime and amended count 2 theft as a party to a crime? What's your plea on each? All right, please raise your right hand. You solemnly swear to tell the whole truth and nothing but the truth so help you God on the matters now before this court. All right, sir, I am looking at the guilty plea questionnaire and waiver of rights document, and I see your signature on the second page of that document. Is that correct? And prior to signing that document, sir, did you read it? Did your attorney also read it to you and go over it with you and explain to you each and every paragraph of that document? Did you understand each paragraph as he explained it? Did he also go over with you and explain to you the constitutional rights that you're giving up here today by pleading guilty to each of the offenses now before this court? And did you understand those constitutional rights you're giving up here today? Let's go over those. Do you understand you're giving up your right to remain silent, not to incriminate yourself? Do you also understand you're giving up the right to compel others to come before the court and give evidence and testimony in your behalf? You also understand that you're giving up the personal right to get on the stand and give evidence and testimony in your own defense. You also understand you're giving up the right to see, cross-examine, and ask questions of the state's witnesses who happen to be your accusers on each of the counts that are before this court. You also understand that you're giving up your right to have a jury trial on each count, and that before you could be found guilty of either or both of these counts, all 12 jurors hearing the case would have to agree on the verdict of guilty on a unanimous basis. Do you understand you're giving that right up today? You also understand you're giving up the right of requiring the state to prove up each and every element of each of the offenses to which you're pleading to here today beyond a reasonable doubt. And is your plea being made here today freely, voluntarily, intelligently, and with full understanding on your part? Have you had any drugs, medication, or alcohol prior to coming to court today? Are you pleading guilty on each of these matters, sir, because you are guilty? All right, counsel, you get a chance to go over the guilty plea questionnaire and waiver of rights document, as well as explain the elements of this offense to your client prior to the plea here today.
Yes.
Are you satisfied that he understands the contents of the guilty plea questionnaire based upon your explanation of same, as well as the elements of this offense?
Yes, I am.
Are you satisfied as well that he understands the constitutional rights he's giving up here today by virtue of your explanation of same?
Yes.
By virtue of your totality of your interaction, do you believe his plea is in fact being made here today freely, voluntarily, intelligently, or with full understanding on his part?
Yes, I do.
Are you satisfied that he understands the nature of the charges as amended, the maximum penalties that could be given upon the conviction, the elements of each of the offenses, as well as the constitutional rights then that are being given up here today on his part by pleading guilty?
Yes.
And based upon all the factors, do you believe there's an adequate factual basis to allow this court to accept your client's plea to the amended counts now before it?
Absolutely.
State consent to the jury.
I do.
Thank you. The court will find here today that the plea on each count is being made here today freely, voluntarily, intelligently, and with full understanding of the nature of the charges, the maximum possible penalties involved upon conviction, the elements of each of the offenses being pled to, and the constitutional rights that are being given up here today by pleading guilty, and the court will accept that plea. May the court then use the facts as set forth in the criminal complaint in order to establish the factual basis on each of these counts as amended by virtue of the information on file today. Mr. Alberti.
Yes, based on the amended complaint of today, absolutely.
Thank you. And Mr. Eichler, you had a chance of going over the initial criminal complaint with your attorney, the one that sets forth all the facts. And now we've amended that several times, but today we're amending it down to the theft matters. May the court use the facts as set forth in the criminal complaint initially filed to be substantially true and correct in order to establish that there is a factual basis so that this court is in a position to accept your plea here today. Thank you. The court will find then that there is a factual basis for the purpose of acceptance of the plea. And based upon your plea of guilty, the court will now find you guilty of the offense of theft as a party to a crime in the manner and form is set forth in the amended information count 1, and to the offense of theft party to a crime is set forth in the amended information count 2. And I will adjudge you so convicted of each of those offenses on this date in order and judgment of conviction entered upon the record. In so doing, I'll ask the state for its basis for its recommendation, please.
Yes, the state is recommending, but essentially I believe boils down to the maximum 9 months at the House of Correction on both counts consecutive, the recommendation being for 1.5 years of incarceration. And then that be stayed and the defendant be placed on probation. The offer includes that as a condition of probation, there will be 30 days at the House of Correction. and that there would be restitution paid to the victims. Did the court want to hear my argument?
Yes.
Thank you, Judge. This is somewhat of a bizarre kind of case. While I understand the importance of a catalytic converter on a car, I can't say that I've run across too many instances in my prosecutorial career where cars are being looked for, or particular cars are being looked at in order to steal the catalytic converter. Looking at the amounts of restitution that the victims had to pay, apparently it is an expensive proposition to repair those. So perhaps that was the motivation behind this particular crime. To the defendant's credit, at the time of his arrest, and this is recited in the criminal complaint, the defendant did admit his involvement. He said that the other defendant, Mr. Krasick, K-R-A-S-I-C, was the basic motivator, or the individual who was actually looking for these particular vehicles. Apparently he had certain types of vehicles, and the defendant, Eichler, was being paid $80 to help out and to be a lookout, and also assist with putting the cars on jacks and jacking it up so that the co-defendant could take the catalytic converter. By way of the defendant's prior record, it is a 2014 conviction for causing injury while under the influence of an intoxicant. First offense, he was sentenced to a 6-month sentence at the House of Correction, and he was placed on 2 years of probation.
Is that it?
No, the computer is, I'm trying to go, and once again, there we go. He has a 2014 conviction for possession of marijuana and a 2012 another conviction for possession of marijuana in 2012. I would just mention that the one of the victims did file a victim impact statement focusing on the inconvenience of figuring out how to pay for his car, getting his car fixed, where to fix it, and then also just the sense of how he can go about parking his car safely in his neighborhood at night. The information I have for the victim for the compensation or restitution is that the defendant the victim BHB had a total expense of $1,280.29. The victim,
Is that on the Cass Street or State Street?
that would be, I believe, the Cass Street.
Because you had the wrong initials down there.
Yes. The victim AAN had $500 out of pocket for the deductible, and the insurance company paid $1,124.50. That would conclude my remarks.
With the 1280.29, was that the total amount paid, or is that just his portion, or is that the combined portion of him and his insurance company?
Let me take a look. I don't see anything indicating an insurance application. I have basically a bill from a Toyota dealer that establishes that the amount was $1,280.29.
All right, thank you. All right, thank you very much. Mr. Alberti?
Yes, thank you, Your Honor. Mr. Eichler, as you have heard, doesn't have any prior theft history. I think this has been a big lesson for him, especially as a new father. He has a 2-week-old newborn son, and as many of us have found, having children and newborns in our lives really changes what is important, and changes us often for the better. And I am seeing that in Mr. Eichler. He has worked at Frontier Builders for a solid 6 years and continues to work there, so he's a valued part of that team. With respect to his newborn son, normally I think we could hope that the mother would be pretty instrumental in rearing that child. Unfortunately, the mother has postpartum preeclampsia, which, if you are not familiar, is a high blood pressure condition. It can be pretty dangerous, oftentimes requiring bed rest. So more of the burden of caring for this newborn child, 2 weeks old, unfortunately is falling on Mr. Eichler. I would note that he just missed eligibility for expungement, as his birthday is in July 14th. So one consequence of these misdemeanors is that they are not expungible. Your Honor, we would ask, well, I would also note that Mr. Eichler did take responsibility immediately for what happened and was cooperative with the police, to his credit. We would ask that the sentences that are stayed be concurrent as opposed to being consecutive, as he is not a prior offender, and I think the circumstances are very mitigated. We would ask, if possible, for electronic monitoring. If that's not possible, we would ask for work and childcare release. And finally, Your Honor, I would ask, if possible, if he could have a week or 2 weeks to report to get his affairs in order, because as I noted, this 2-week-old child is really in need of care. So I think there's some logistics involved there, Your Honor. Thank you.
Thank you. All right, what do you want to say, Mr. Eichler? Pull that microphone up, young man. Well, you know, I don't know if you have learned your lesson. That's the problem. You know, for a guy who's got 14 years of school, that puts you in about the 97th percentile of the persons I see here, as far as your educational background is concerned. You're certainly not thinking with your head. Now you got a young lady, I mean, that's your business about impregnating her and everything else. Now having a child with all sorts of responsibilities that you're not obviously up to, at least you haven't shown it to date. And you know, and your record is not exactly the most stellar anyway. You're dealing in, you're using drugs, you're intoxicants. I mean, you know, you got to wake up, man. That's all I'm saying to you. I mean, the school's over for you, is what I'm saying. Because at this stage of your life, you decided apparently you want to take on responsibilities that you may very well not be equipped to handle. That's very, very unfortunate, particularly for you, but also for the innocent child. So you better start toughening up and start figuring out that the right way to do things is the right way. And now you're going to be the primary first teacher of that child the new child. Now you got a little daughter too. So you got your primary teacher for her. You want to teach her how to be a thief? Well, exactly. I mean, these are some things that are just common sense in life. And you as a parent now are going to be primarily the person responsible for developing these people on their moral compass. So understand, it's a big responsibility, and there's no book learning, if you will, that's going to teach you that necessarily. It's going to have to come from your heart and from your gut, but it better come with the right thinking in mind. And that's all I can say to you, because you're at a point, you're at a real cusp point in your life, going forward. Now I've got to consider that, because I have to consider what you've done here. I've got to consider your overall character. And my point is, why the heck are you here with your educational background, with the abilities and obviously abilities to think in your bailiwick of abilities? It's just nonsensical, selfish type of conduct that'll get you nowhere and get you only put in jail. So understand that, and that's something we don't want for you. We don't want it for your family. It's such a waste. I fully agree with that. But sometimes retribution or punishment, if you will, is appropriate, because nothing else has seemed to work up to now. You just keep being a repeater as far as conduct is concerned, and it's got to stop. So if you do that and get your head on square, we're with you. If you don't, you should be punished, because you're not doing anything right anyway then. So I do have to consider all those things, because I have to consider not only what I have to do to punish you and what I've got to do to protect society, I have to consider what it's going to take to finally rehabilitate you and have you stop this type of course of conduct. I have to deter you and others from doing this ever again. And I certainly have to consider the need to punish is there. There's no question about that. This isn't a new show. You've been involved with the justice system. This is the fourth time at least. God knows how many other times went by the wayside that you did things that you could have been involved with the criminal justice system. I'm not punishing you on that aspect, but you know what I'm talking about. And all I'm saying to you is you got to stop it and go straight and be a good parent, be a good person, be a good citizen. That's all we're asking of you. All that being said, the court does feel under all the circumstances that the following is a fair and reasonable sentence. That's to count one, the theft count. I will give you 9 months in the House of Correction, imposed but stayed and placed on a 2-year probation. I will require as a condition of the probation in that count that pay full restitution on a joint and several basis with you and your co-conspirator, co-actor. You may end up paying it all. That's what you get for getting in bed with the wrong guy. But that's the way it is. $1,280.29 is due DMH, as I understand it. I'll order that be paid in that matter, and that I will give you all the requirements as well. Certainly no contact with your co-actor, no contact with the victim. I will give you 30 days condition time. I will give you human release for work and child care. And I'll set that report date 2 weeks from today's date, which will be what date, Madam Clerk? 9/11, an auspicious date, I might add, at 5 p.m. We'll be reporting to the House of Corrections out in Franklin. I will also tell you here today that you are going to be required to give a DNA sample of your body and pay the surcharges for that. You're going to be responsible for paying the cost and disbursements of this action in its entirety as a condition of the probation. Understand that. As far as count 2 is concerned, the court will give you 9 months imposed in state consecutive and then place you on a 2-year probation concurrent with count 1. All the terms and conditions are concurrent in count 2 that they were given to you in count 1, except that the amount of restitution payable on a joint and several basis, and that count is totaling $1,679.50, with the first $500 payable to the victim, AAN, and $1,124.50 payable to his insurer. What's that name of that insurer? Let me know the name of the insurer when
I
you get
don't
it.
see it in the documents I have.
Well,
Oh, USAA Casualty.
USAA Casualty Insurance Company, $1,124.50. Thank you, sir. I will tell you here today that you have to give a DNA sample on that particular count as well, even though it seems duplicitous. That's the way it is. That's the way the statutes call for it. I will not require a secondary costs and disbursements on count 2, however. The court will tell you that on each count you have the right to certainly appeal this matter. You have 20 days from this date to pursue same. If you don't, that could be waived. Your attorney did file the necessary documentation in that regard. And if you have any other questions concerning that, certainly go over that with him. As far as the other matters are concerned, I'm also going to require in each case a parenting counseling. I want you to know how important it is for you to be a good mentor, a good example, a good father. That may be the most important thing you're doing from this point on in your life, in seeing as how you've gone to the actions which brought this baby into the world. 2 children now. Now you're going to have to see them through it. Don't show them the wrong way. I will tell you then that as far as any credits coming, does he have any?
Your Honor, I believe there are 3 days of time served.
He will have 2 days credit going against the count 1 imposed in the state sentence should that have to be imposed. It's no credit on count 2 because that's consecutive as far as the incarceration phase is concerned. Again, I wish you the best of luck. I hope we don't see it. Tough, hard lesson for you to learn, but sometimes tough love is what it takes. Hopefully in this case it'll work and we won't see you again. I will wish you good luck, and the report date, again, I remind you, is September 11th at 5 p.m. To the house out in Franklin as far as the incarceration phase is concerned. You understand all that? All right, any questions, check with your counsel. Thank you. Any questions?
Your Honor, just a quick clarification. My notes, I have 30 days of Huber condition time, and that's on count 1 only. Is that correct?
I did not give any condition time in count 2.
Thank you, Your Honor.
I only gave it count 1, so it's, once that's done, it's going to face the other stuff they impose in state without having encumbered. All right, that said, that'll be the court's order. Anything you have,
I
Mr.
just asked for a repeat on the length of condition, length of probation.
2-year probation on each count. All right, they're 2 years. They're both concurrent, though, to each other. The only thing that's consecutive is the imposed in state portion. All right? All right, very good.
Thank you, Your Honor.
That'll be the court's order in the matter. Thank you.
Thank you.
You may. Thank you, Kristen. No, I mean that. Sometimes, I just get carried away.
Good day.
Two. Don't be like that.
I was in the middle of putting on motion yesterday and the VPN disconnected.
Yeah.
And then I wouldn't reconnect and then I wouldn't take the new.
Mm-hmm. Okay.
And I was like, God damn it.
So you have 3 of them here today? You have 3 here today?
Oh, okay. Well, I've got
I know Roslyn.
scheduling.
Yeah.
Roslyn's all ready to go. She's gonna have to appear by Zoom because she's in a quarantine pod, but I filed everything. And then I had to refile, and then I had to refile it again because I made the mistake of scanning the jury instructions along with the plea form. Once you scan something, you can't separate them when you file. I tried just retitling the different things, and the clerk's office rejected them. I'm like, thanks, appreciate it.
Okay, and then who else do you have?
I've got sentencing on Darius Williams. There's a pre-sentence on that. That's Griffin's case.
And that's just a sentencing? Or is it a plea and fee? Is it a plea and
No,
fee? Okay.
there's a pre-sentence.
Okay, yeah. I
There's a
think,
pre-sentence.
yes, I think he sent that to me.
And then I've got plea and Eric Jones, which is just a plea we're asking for pre-sentence. The state's asking for pre-sentence, and that's fine. And Campbell, which is not.
Yes. Hopefully I can get through that one. Without too much.
I just filed a defense memorandum on that case. And if you hadn't had a chance to read it, I have a hard copy for you to read if you want to read it.
Oh.
On Campbell?
Oh, on Campbell? Yes, I'm sorry. Yeah, give me the hard copy, please.
You have the hard copy?
Yes.
Okay. I know, I was like, why do all of them?
I know Chris sent me here it is, pre-sentence investigation. Darius. And this one is for Campbell. Okay. Yes, the one that I have. Okay.
Well, 2 of them are scheduled at 10:45. Okay. So Williams and Jones are set until 10:45.
10:30, okay.
Campbell's in custody, they're going to have a report by Zoom. And then Watson's here to see if they.
Watson, Campbell. That's fine.
Okay. Well, here's the thing, I don't generally bother to come in during the day because I can't keep the working schedule straight. It's a jacked up. Well, I thought it's on the Google Drive. And it's not very informative. Usually it's like, okay, well, it's not big. I'm sitting at home and just come after hours. And allow them to maintain liability. It's just easier. It's easier. The one time that I had to come, I got jammed up because I had an in-person parents and I had Zoom. I refused to run that I won't do that. So I just said, that one, I had to run over to the office and have, and that's before they have the satellite set up with, so the CJF one, you can do it now, but it didn't have a camera there, so I had to run into the office and say, this is because oh, I know, they bumped it to the afternoon because there were issues and they gave them all the time. And it was a case that dragged out forever, and I'm like, fine, I'll come back this afternoon and get it done. But then Kaiser's emailed me a quick email, and I emailed her in the morning telling her what was going on. And they're still in the record here. And Dee was like, well, he said, we was like, equipment. I called this because they have a so then I sent her out to the office and like, and basically, so I've got to use a computer to do a Zoom plea and sentencing for Judge Kais. And Virginia was nice enough to let me take her to her office and take over the computer. Virginia. I know. Because I came in and Edward was still there and I'm just like, Edward, you know, it was all. He's like, yeah. I agree. Because but I'm just like, you know, this is just fun. It's weird. It's just the weirdest thing. I'm like, how am I so like? Well, I'm just, you know, it's like, okay, fine, you need to maintain deniability, fine. Well, and the thing, okay, so here's the problem. Is the things that created all this work. We never used to scan anything. You know, we didn't scan 3 forms, we didn't scan any of that stuff. Right. Well, then I changed it, last week we gotta call it 8 people. But, you know, like I said, in Evan's thing, with the PDF signature, left out a big step. I spent like about 4 hours on stage. If you scan your signature, it comes to you as a PDF. And Adobe can't recognize PDF. So you'll search for an image and you're like, well, there's over here. And if well, if you don't do it that way, and you know, I don't, electronic signature just bothers me. It's like, what anybody signature, right? So.
I don't see a word down here. Gaston. I thought it. Watson?
Yes, yes.
State of Wisconsin versus Iris. 20 CF 0302. Appearances, please.
Stephen Glam appears on behalf of the state.
All right. We're here on a status conference. What do you want to do with this case, Ms. McCandless?
I've received discovery, received an offer. I have spoken with Ms. Watson regarding how she would like to proceed, and she advises me that she wishes to have this set for trial.
All right. Trial date, final pre-trial date.
February 22nd for breakdown.
Okay.
January 20th for final breakdown.
Okay.
All right. 10 days before the final pre-trial, please get the get your final decisions in, your witness list, any motion of eliminate, so that I can, whoever's here can make a decision on the pre-trial date on those matters for any ones you cannot stipulate to. All right. Thank you very much.
What time, please?
So next court date is January 20th, 8:30 final trial, February 2nd, 8:30 for trial.
Okay. Yep, you're good.
Okay, who do we got now?
Can't, is Campbell gonna be a bit yet?
All you have to do is ask.
Mr. Jones is here. So if we wanted to do the plea on Mr. Jones, we could do that. Yeah, this is just a plea. The state's asking for a pre-sentence.
Can I just,
Oh, you know. Mr. Jones?
Yes.
Does he require an amended information be filed?
I don't know, see, I gotta figure out what the negotiations are.
Oh, well, that's not a problem, because I have it in writing here. somewhere.
So we're just dropping the armed, is that it?
Yep. Sure. All right, so he can identify himself, so I'm fine with that. Okay. Mr. McCandless? I'm Jones. He's in a quarantine area.
Jones is right here. That's Mr.
Wait,
Campbell.
wait, stop. Jabbering. What's going on?
This is Mr. Campbell.
Yeah, but another, okay. Are you here in Jones too? Well, we do Jones while they're getting the other guy, because it'll take us only about 10 minutes. Okay.
That's fine with me.
I do need to do an amended information apparently.
Oh, geez. Well, then we're gonna spend a lot more time than that. Just, it has to be done. We gotta do it right, Mr. McCandless. That's it. Please. Do the amended information. Let's get it going.
I am going to have words with these people. I will be having words with these people.
And yeah,
It's
okay.
a refusal, but his OWI 4th is scheduled in October, so I'm gonna move it to that date.
Okay, that's fine. Very good. Thank you.
You guys. So we had a case on the calendar yesterday, Sean Ross, and his client didn't appear. So we never called it yet. He's got a few cases, but I know he said he's had good contact with Justice Point and the state benchmark. If you mind covering while we're waiting. By chance, I mean, if it's okay if you don't.
As long as the state's not asking that there be an immediate benchmark.
Wilton State is fine.
That's fine, okay. All right.
This just is crazy. Okay.
Sure. All right, well, we're doing other things. You have to make an appearance on these, Mr. Graham, but these are people that we had to move yesterday because of the time block. Okay. State of Wisconsin, Jason Beechster, 16 CT 1465. Appearances, please.
Stephen Glam appears on behalf of the state.
Victoria McCandless appears as a friend of the court for Attorney DL, who was here yesterday as counsel of record.
He was here yesterday as well, by the way, and I note that. But we just had we had over 80 cases, 50 in the morning even. So let's go ahead and we're going to give them a new date on that. Okay, the other one's right. Beechster is also here in the state of Wisconsin versus Jason Beechster, 14 CT 1192. Also, state of Wisconsin versus Jason Beechster, 20 TR 5058. And state of Wisconsin versus Jason Beechster, 20 CF 0783. I note your appearances on all of those cases, people. And we unfortunately have got to move them to another date, which is going to be what, Madam Clerk?
September 16th, 8:30. Yeah, it says.
All right, everybody.
That was a bench warrant stayed.
I'm going to issue a bench warrant, but stay until the next court date to get things back on track.
Thank you. I lost internet.
You what?
I lost my internet. All right. Victoria, do you want to take a look at the amended information? The little blue circle of death. I issued PTAC. I don't know why.
Whatever. Okay, so it should just be through force because it was it was amended down from armed robbery, so it wasn't actual force. It was just threat of force. Sorry.
That's okay. That's why I asked you to look at it. You just got to catch her so she rejects it.
So, you know, it's so complicated,
Sorry, come here, Phil. I really can't hear you.
Just only time when you really need it. It's just
I know. You can't listen. Everyone's just got to be a little bit patient in this whole deal. I mean,
And I do thank you for your patience.
oh, well, you never had those issues.
Also, one of our other attorneys is like, oh, you could do this and make a PDF signature. But you left out a step, and I stopped while I was trying to do it the way he said, and I'm like, wait, you left out the. If you scan your signature, it comes out as a PDF document. And when you go to image in Adobe's like, huh? There's no image because it can't recognize this PDF.
I know, but it's everything. It's all that kind of stuff, and all of us miss some steps. You know what I mean? And the older you are, you never knew the steps you're missing. So that really makes it more difficult. But you know, it's you know, you just got to do your best, especially under these circumstances. I mean, you know, I'm 2 or 3 generations away from this. You know, almost. You know, when you think about it, I'm 73. You know, go figure. I mean, I'm not. I mean, I try my best, but.
If you can figure it out.
Well, if you can figure it out, that's a very good big if. I know. I hear you. I feel it's kind of like when I was in school, they always wanted everybody who's going to go to college or whatever to take it to Spanish. Think about that. You know what I mean? And I think the dumb kids used to take typing. Hell, I wish I'd taken typing so many times ever since I went to school, and you know, learned how to do that. Of course, now you're absolutely required. Well, I hear you. Are we almost ready here?
Yes.
All right, very good. Let's get back to work, everybody.
Okay. I now have the threat of force.
And which page are we on? I'm sorry.
There were left out an important step. If you sign your name and scan it, it's going to scan as a PDF. And when you go to Adobe,
I'm looking right now.
the steps and click on image, and go, huh? There's nothing here because you can't see a PDF. It has to be a JPEG or some other format. I didn't. I said I sent him an email today saying
I don't see anyone in the waiting room.
He's like, oh yeah, that's right. Well, you could, and then he said how to do it, and I'm like, okay. So
There's a video dependent on there somewhere. MC video. Let me.
I know. Okay, so I'm ready on Jones.
Yeah, would you like to look at it? At least I can say I showed it to you. There it is, threat of force.
That's perfect.
2016.
Yeah. What happened is, Brandon Wigley dismissed it on the day of trial last time he was charged. Why? Because he was in that way.
Yeah.
There's indiscretion. I guess the witness problems was so bad.
Okay.
Anyway.
Good.
Yeah. And the Griffin got hold of it. It's like, so you want me to have Mr. Jones come in? Are we ready for him?
I don't know how long before that guy's going to be at that phone. You know? No. I mean, do we have something? Do we have time to do somebody else, or no?
I mean, I would just actually.
Okay, so now 9.
Okay, okay. Hold on, it's not working there. Right?
Yeah.
For whatever reason, they're having problems with that.
I'm calling it right now.
Oh, you did? Okay.
I don't know. I'm asking you. Did we have?
You said concurrent to each count, but consecutive to the current
Okay.
sentence.
All right.
That's what you said. So that's what I told her.
That's good. That's what I. Sometimes I get confused. Many times, too many times. That's why when I retire, I'm going to get a job with Piggly Wiggly. Where all I have to do is ask paper or plastic. And on Thursdays, I have to remember to say, "Are you eligible for the senior discount?"
Or you could just go to Home Depot and make it up as you go, because most people know what the fuck they're talking about.
Yeah.
Although they don't check their employers' employees very well, so maybe I could say spell choice.
Oh, that was on speaker and most of the other ones.
You do that on a cell phone, then it's a line. That's never.
Put it on speaker and just put it on a. Right here.
Yeah, this one's on.
Yeah, but we have to get
Both.
what did that put it up on the judge's mouth? Is that one?
No, no, according to the jail, I can't. Because it's a quarantine pod, I don't know.
Warranty, but
Okay.
what's this guy's name again?
Roslyn Campbell, and it's female, Your Honor.
Thank you. Gotcha.
Yes, Ms. Campbell? Because this is your attorney on the court, and because they're in a quarantine pod, they cannot have you appear by video or bring you to court. So the only way that we can proceed is via phone. Okay, so you have no objection to proceeding by phone? Okay, I figured as much, but I needed to ask you. Okay. So we're just about to get started.
I'm just gonna turn it down for this proceeding only.
That's okay.
Well,
Okay. We have the state of Wisconsin versus Roslyn Campbell, 20 F917. If I could have the appearances, please.
Stephen Glam appears on behalf of the state.
Victoria McCandless appears in person on behalf of Roslyn Campbell. Ms. Campbell is in custody at the Criminal Justice Facility and is appearing via phone due to the fact that she is housed in a dorm or pod that is quarantined because of the COVID-19. And this is the only arrangement we made for her appearance. I just informed her of that, and she has affirmatively agreed that she is waiving the right to be personally present for cleaning sentencing and is ready to proceed in this fashion. Is that right, Ms. Campbell? Okay.
All right. The court is noting because of the special circumstances due to this COVID-19 and her quarantine status, the only way she can appear is telephonically, and therefore the parties have all agreed that they will not object to this, and that they are satisfied with the telephonic protocol under the circumstances here. Is that correct for the state?
That's correct.
Is that correct for Ms. McCandless in defense?
Yes.
All right. That being said, I do have an amended information somewhere.
No,
Let me.
not for this case.
Not this joke, right? I have to say, let me. This is the. What is the recommendation from the state on this matter?
If the court accepts Ms. Campbell's guilty pleas to the two charges that are that are charged, the state is going to recommend restitution for all victims, 6 months imposed on each count, concurrent to each other, but consecutive to any other sentence.
All right. Any other conditions?
No.
Other conditions up to court?
Yes.
Gotcha.
It is.
All right. Is that a correct statement of what you understand the state's recommendation to be in this case, Ms. McCandless?
Yes.
Ms. Campbell, is that what you understand the state's recommendation is to these particular charges?
No. Okay, Ms. Campbell, the court's just asking you if you understand that the DA recommendation here is 6 months on each count, concurrent or consecutive to your revocation. Just asking you to understand that's a state recommendation. Okay, all right.
You understand that, Ms. Campbell? I need a yes. All right, the court will accept that. Let me tell you, Ms. Campbell, that you're being charged in count 1 with threat to a law enforcement officer. Upon conviction of that particular matter, The maximum penalty is a fine of not more than $10,000 or imprisonment for not more than 6 years or both. Within 6 years, up to 3 years probation, followed by 3 years extended provision. Do you understand, ma'am, the maximum that could be given upon conviction of count 1 with respect to a law enforcement officer? In count 2, you're being charged with damage to property. There, upon conviction, the maximum penalty is a fine of not more than $10,000 or incarceration not more than 9 months for both. Do you understand the charge of criminal damage to property and the maximum penalty I just went over with you? Do you also understand that even though the state has given this court a certain recommendation, I'm not bound by the recommendation. I will certainly consider it. I'll consider what you and Ms. McCandless have to say. But understand, I'm not bound by what any of you have to state, neither the state, nor you, nor your defense counsel. But the court is reading whatever it feels to be the appropriate sentence up to the maximum I just went over with you on each count. Do you understand that now? Do you also understand that if you are not a citizen of this country, and upon finding of guilt by this court for either or both of those counts, you could be deported, denied admission, or denied naturalization to this country should federal law be applicable to your particular circumstances. Do you understand this as well? You also understand that in order for the state to prevail on this case, they must be in a position to prove up the state beyond a reasonable doubt. And they do so by proving up elements of the offense to which you're pleading to here today. Has Ms. McCandless gone over with you and explained to you the elements the state would have to prove up on each of the counts now before this court? Now, I have a guilty plea form in the addendum form filed in this matter. And let me just double check one more thing. I do not have the element sheet or a jury instruction, and so I'm going to have to ask you: did you go over those elements with my client on each of these particular matters?
I did, and they have been filed, and I can give those copies to the court.
I am now looking at the jury instruction 1240E, with respect to a prosecutor or law enforcement officer, indicated by Ms. McCandless that she had gone over this with the defendant. Notes that there are some elements to this offense, and I want to also note that she went over Wisconsin GI criminal jury instruction 1400, criminal damage to property, with Ms. Campbell, and elements are noted there as well. Do you recall going over those documents with your attorney, Ms. Campbell? And did you understand those elements? She explained them to you. All right, let's go over and apply a lot of those elements to the factual matters that would have to prove up in this case. In count 1, with respect to a law enforcement officer, the state would have to prove that you did on or about February 25th, 2020, at 819 North 6th Street in the city and county of Milwaukee, state of Wisconsin, that you did intentionally threaten to cause bodily harm to Joseph Barr, a law enforcement officer, without his consent, and at the time of the threat, the defendant knew or should have known that Joseph Barr was a law enforcement officer and the threat was in response to any action taken by a law enforcement officer in his official capacity, all contrary to sections 94203 sub 2 and 939.50 sub 3 sub H of the Wisconsin statute. Do you understand, ma'am, the factual elements the state would have to prove up beyond a reasonable doubt as to count 1? In count 2, the criminal damage to property count, the state would have to prove that you did it again on February 25th, 2020. This time at 149 North 9th Street in the city and county of Milwaukee, state of Wisconsin, that you did intentionally cause damage to physical property of the Wisconsin Correction without the consent of that person or entity, contrary to section 940.01 sub 1 and section 939.51 sub 3 sub A of our statute. Do you understand then, ma'am, the elements the state would have to prove up beyond a reasonable doubt as to count 2, criminal damage to property? And have you, attorney, had a chance to discuss each of these matters thoroughly? And do you understand all the possible defenses, strategies, or tactics that we might utilize to defend against each count now before this court? And based on all considerations, then, ma'am, what is your plea to count 1, threat to a law enforcement officer, and your plea to count 2, criminal damage to property? All right, please raise your right hand. I promise to tell the truth, nothing but the truth, so help you God, the matter now before this court. All right, thank you. All right, I am looking at your guilty plea questionnaire and waiver of rights document, and I see your signature on the second of that document. Is that correct? Prior to signing that document, ma'am, did you read it? Did your attorney also read it to you and go over it with you and explain to you each and every paragraph of that document? And did you understand each paragraph as you explained it? Did she also go over with you and explain to you the constitutional rights you're giving up here today by pleading guilty to each of the counts now before this court? And did you understand those constitutional rights you're giving up? And let's go over those. Do you understand that you're giving up your right to remain silent, not to incriminate yourself here today? You also understand that you're giving up the right to compel others to come before this court and give evidence and testimony in your behalf. You're also giving up the personal right to get up on the stand and give evidence and testimony in your own defense. You also understand the right to proceed, cross-examine, and ask questions of the state's witnesses who happen to be accusers of the counts now before this court. You also giving up your right to trial by jury on each of these counts, and that before you can be found guilty of both of the counts, the particular jury hearing that would have to agree to be guilty of verdict beyond on a unanimous basis. You understand? And you're giving that right up. You understand that? All right. Lastly, you understand you're giving up the right of requiring the state to prove up each and every element of the offenses charged in being pled to here beyond a reasonable doubt. All right, thank you. And is your plea to each of these counts then being made here today freely, voluntarily, intelligently, and with full understanding on your part? Have you had any drugs, medication, or alcohol prior to coming to court today? And are you pleading guilty to each of these counts, maybe because you are guilty? All right, Mr. Canlis, have you had a chance of going over the guilty plea questionnaire and waiver of rights document, the addendum document, as well as the Wisconsin instruction referred to by the court earlier, Mr. Campbell, prior to the plea here today? Are you satisfied that she understands the contents of each of those documents based upon your explanation of saying to her?
Yes.
Are you satisfied as well that the plea is in fact being made here today freely, voluntarily, intelligently, and with full understanding on her part based upon the totality of your interaction with her?
Yes, Your Honor. And one thing I just want to mention for the record, she is prescribed a number of medications for a mental illness, and it's my understanding that she has been taking those medications as prescribed. So I just wanted to make that part of the record.
Well, let me ask you, Mrs. Campbell, is that medication you're taking for your mental health situation, is that in any way affecting your ability to understand or appreciate what is going on in open court? Is it in any way affecting your decision-making ability? All right, we'll proceed. And are you satisfied then that her plea is being made here with full understanding of the nature of the charges, the maximum penalties that could be given upon conviction, the elements of the offenses being pled to, and the constitutional rights being given up here today by virtue of her guilty plea?
Yes, Your Honor.
All right, and lastly, do you believe there's an adequate factual basis to allow this court to accept your plea here today?
Yes.
Thank you. State consent to the jury waiver.
I do.
The court will approve, and the court will find here today that the plea in this matter is being made here today freely, voluntarily, intelligently, and with full understanding of the nature of the charges, the maximum possible penalties involved upon conviction, the elements of the offenses being pled to, and the constitutional rights being given up here today by pleading guilty, and the court will approve. May the court then use the facts set forth in the criminal complaint to form the factual basis, Mr. Campbell.
Yes.
And Ms. Campbell, you had a chance to go over that criminal complaint yourself prior to your today? Have you? Ms. Campbell? Have you had a chance to go over that criminal complaint yourself and with counsel prior to the plea today? Okay, well, there's a delay there. And I want to make sure I got that. Now, based upon your reading of that criminal complaint, may the court use the facts that set forth in that criminal complaint to be substantially true or correct in order to establish that there is a factual basis so that this court is in a position to accept your plea here today. Thank you. The court will find then that there is a factual basis for the purpose of acceptance of the plea, and based upon the plea of guilty, the court will now find you guilty of the offense on count 1 of threat to a law enforcement officer, and to the count 2 damage to property count in the manner and form as set forth in the criminal complaint. And I will adjudge you to conviction of each of those offenses on the state order and department of conviction entered upon record. In so doing, I'm going to give you 2 admonitions right now. One is, as a convicted felon on count 1, you never again for the rest of your life ever possess a firearm. Do you understand that? That's the second admonition says that you cannot vote in an election until the entire sentence I'm giving you on these matters has been completed. Do you understand that your right to vote is hereby suspended until such time as the sentence is completed and your civil rights are restored? All right, thank you. All right, basis state for your recommendation.
Thank you, Judge. This all goes back to an incident that occurred back on February 25th of this year at the state office building right across the street. Essentially, Ms. Campbell was in the DMV, and there was a disturbance caused by her. I don't recall the exact nature of it. I think it was with another citizen who was at the DMV to do some routine business there. Because that is the state office building and there was a disturbance, so the officers that responded to the report of the disturbance are from the State Capitol Police Department. When the defendant was initially approached, the officers did try to calm her down, but she became belligerent, started using vulgarities and profanity, and eventually, at least for a while, the officers were able to de-escalate her agitated state. However, later on, the defendant again became disorderly. The officer decided he was going to take her into custody, and that's when the incident occurred where there was somewhat of a resisting and the threats were made to kill the officers. Ms. Campbell was on probation at the time, and I believe the officers knew that, and they knew that her agent it was pretty good at being able to calm her down, so they contacted the agent, but the situation didn't resolve with the agent. Things escalated. Eventually, the agent decided to take Ms. Campbell into custody, and the criminal damage charge is a result of the transfer by the agent using the state van to get to the CJF. And at that point, the defendant was able to use an ice scraper that was in the car to smash the rear view mirror. In this particular case, I should note for the record that we have given notice to the victims of today's proceedings. I've not received any information indicating that there is a request for any restitution. By way of prior record, the defendant has one conviction. That is a conviction for robbery use of force. That is in a 2017 case. The defendant was sentenced to 3 years in the state prison, initial confinement, and 3 years extended supervision, and placed on probation for 2 years. I note that from the criminal complaint that the defendant was aware that she was about to complete that probationary period, indicating that her time was going to be up on March 2nd. My understanding is that she has been revoked, and I've taken that into consideration in making my recommendation. I am recommending 6 months each count, concurrent to each other, because essentially although two distinct actions, they're all part of the same day, same incident, if you will. But I do think that it would be important to have an additional period of time over and above that which she is going to serve. And that's why I'm recommending that the 6 months concurrent to each other on this case be made consecutive to the sentence she is now serving. There is no additional prior record. Ms. McCandless did share with me the pre-sentence that was written by someone in her office. I see that Ms. Campbell has a history of mental health issues and drug abuse issues, which of course, when mixed together, are not really conducive. They're just a recipe for disaster. And my suspicion is that back on that date in February, that was what was going on, that there was some sort of failure to maintain medication and or drug abuse. So under the circumstances, I think the state's recommendation is fair. I think it's warranted, and I would ask the court to follow that.
All right, Mr. Canlis, what do you want to say, ma'am?
Your Honor, it is absolutely true that Ms. Campbell's mental health situation had a great deal to do with how the situation unfolded on the date of this incident. She had sort of fallen through the cracks in the system. She was not on her medication. And when she's not on her medication, she is not able to behave appropriately. We did file with the court the social history, which sort of details some contacts that she had with various service providers in early 2020. And they indicate that probably as of January sometime, she really was not in a stable mental status due to medication issues. Also during that time, she was homeless and sort of living place to place. I know that she exhibited a great deal of frustration in trying to work with her agent and obtain needed services. And unfortunately, it all culminated with her acting inappropriately. What I can tell the court, though, and what I think the court should take into consideration is this was, there were a lot of things said, but there was not anything violent by Ms. Campbell. The criminal damage to property did involve her breaking the rear view mirror in the DOC vehicle, but that was the extent of the damage. So it is not the case that she completely went out of control and actually caused bodily harm to people. And I think that that makes this situation different than if that had occurred. She did get revoked directly because of this incident, and the state is right. She was very close to completing that probation, so she'd been able to keep herself on track for a couple of years, which for her was a big accomplishment. And then it got derailed at the last minute and she found herself revoked. So I'm not going to tell the court that I think that the state's recommendation is unfair. I don't think it's unfair. I would ask the court, though, to consider that she has 3 years to serve in. There is some credit for time served on that. And then she's going to have 3 years of extended supervision when she's released. So there's no real purpose here for any additional supervision because she's got the 3 years already in place when she's released. But what I would ask the court to consider is making this a concurrent sentence only because this was the incident that triggered the revocation and because of the fact that I believe that a large component of this behavior was due to the fact she was not on her appropriate medications at the time. But it does indicate, based on the records we have, that she had made some legitimate efforts in that regard. So even though in the end, legally, any conduct that she engages in is her responsibility, I do think that there's these other issues that the court could consider that would justify a concurrent sentence.
Thank you. What do you want to say, Campbell?
Yes, Ms. Campbell, it's second time to talk to us, want to say anything to the judge.
Just, did you get most of that, or? All right, I appreciate that. Well, you know, the problem you have here, Ms. Campbell, is that your life is so much in your hands because you gotta be on those meds. If you go off the meds, anything can happen. You know, anything can happen. And unfortunately, The law says if you are supposed to consume medication and you don't, and that puts you off the charge for behavior is concerned, then you hold on to it. Same difference if we're a drug addict, took too much drugs, and then you went out and something foolish. The fact that you took those drugs and put you in that state does not allow you to necessarily be relieved of responsibility for criminal misbehavior. And so, you know, it's so important for you as a person to stay on your head and keep yourself under control. If you do that, I think you'll be okay. If you don't do that, you have these kinds of problems. And to be quite candid with you, the only time that you seem to be overly compliant is when you're under control of the state by virtue of some type of incarceration or the like. And all I can tell you is that is know that. But it's going to be your choice, because now you do have control of yourself. You do understand the fact that you need the medication regimen, and if you do go off it for whatever reason, you're just looking to have trouble. And we don't want that for you. I realize you don't want that for yourself, but that choice is now up to you. So the court has to consider certainly the seriousness of this offense. I have to consider certainly your overall character and certainly mental health issue is a factor. I have to consider what's it going to take to rehabilitate you, as well as what's it going to take to punish you and deter you from doing this type of behavior again. We don't want this from you, and we don't want you to get hurt. We don't want you to hurt others, and I think that's your duty to do. If you do all these things, and considering the seriousness of the offense, but also the need to punish you for what you've done, especially under the fact that you're under supervision requirements at the time, it showed somewhat of an utter disregard of your responsibilities and being compliant with court orders. All that being said, the court will give you in count one a 6-month consecutive stay prison system. I would hope, and I would recommend that you do get mental health evaluations as part of your inpatient, your incarceration treatment role arrangements, as well as an management type of consideration. Certainly, you assessment treatment as well, and your DNA of your body, including paying the surcharge connected with that as part of this deal. You're also going to have this action. I have not been advised of any restitution that's being sought in this matter, but that doesn't mean that sometime we still have jurisdiction over that within 50 days of today's date, but it could get sued, I guess, by the city if they wanted to try to get you to pay for their damages clause, but I'm not going to deal with that today. As to count 2 for damage to property, I'm going to give you a 6-month current sentence on that. It's 6 months. I'm giving you in count 1, and under those circumstances, you do have to give another DNA sample of your body, even though I agree it seems like a redundant situation, but that's what the statute requires. So I got to give you that. But I am not going to require you to pay a second set of costs and disbursements under those considerations. They will be allowed to take monies out of wages to pay for anything the court ordered financially to be paid under the circumstances. And then if not paid by the end of your incarceration stay or any ES time that you might have, I don't think there's any ES being incarcerated for that time period. The court would allow for a civil judgment to be entered at the end of your prison stay for any balance remaining to be paid under the circumstances of this court's order. I will tell you as well that you have 40 days from this day to pursue any post-conviction relief that you care to. Ms. McCandless will hold those documents with you and make sure you understand them, and then exercise them or waive them as you see fit. I wish you good luck, and hopefully we won't have to hear again on this stuff. But understand, I think that's really up to you at this juncture. So stay with that.
Okay. 6 months. Correct, Roslyn, the judge gave me 6 months concurrent on each case of consecutive to the revocation, okay? So I will come and see you after and explain everything to you. Yes.
All right, ma'am. I'll read in at this time for the sentence. Thank you. Remember my last day was my last day. I was on the bench. We had all the. It just happened that all I had were women in my court. Remember, I had women DAs. I had, I mean, everybody was a woman except for me. So they were referring to these women as my harem. Oh well. All right. Well, thank you, Mr. McCandless. I appreciate that. Now, you have Jones?
I have Jones, and he's on deck here.
All right. Well, let's get him in here. Dates on well, as long as Jones, he's here. The other two, if we have time, we'll do them. If not, go ahead and get them off the record. Hi. Probably at 1:30. I can only, it's running out of time. It's been up at 1:30. We can get them here at 1:30. Deb? Well, if we do it by Zoom, I don't mind, but I don't like that telephonic stuff. Yeah. If you're willing to do it by Zoom with your client, we are too. Easy for us. We don't bring them over here. Then can you get them set up at 1:30? All right. Let's figure on doing that, okay? We'll get you in and out at 1:30. It's all I can tell you, okay? We got one more guy here to do it while he's here. And Mr. Jones, come on up here. All right, we are calling the state of Wisconsin versus Eric Jones Jr. 18 CF 55 appearances, please.
Stephen Glam appears on behalf of the state. I'm appearing for Assistant DA Jim Griffin.
Victoria McCandless appears on behalf of Mr. Jones, who is here in person.
All right, we're here on a plea hearing on this matter. May I have the state's recommendation?
Yes, the state today filed an amended information charging the defendant with 1 count of robbery, threat of force. My understanding is that the defendant will plead guilty to that charge. At the time of sentencing, the state is going to leave sentencing up to the court in all respects, full restitution to any victims. We're also requesting a pre-sentence investigation.
All right, Ms. McCandless, is that what you understand to be the recommendation of the state under the circumstances of the amended charges now before the court?
Pardon? I'm sorry.
Is that what you
Yes.
understand to be the state's recommendation
Yes,
in this matter?
it is.
And now you've had a chance to see the amended information in this case?
I did.
And would you waive its formal reading and enter a current plea of not guilty, at least until such time as the court would accept the guilty plea?
Yes, I would acknowledge virtual receipt of a copy of the information, waive reading, and until such time as the court accepts a change of plea, enter a plea of not guilty.
All right. The court will first of all accept the amended charge in this case, to that being robbery by threat of force. There, upon conviction, sir, the maximum penalty is a fine of not more than $50,000 or imprisonment for not more than 15 years or both. Do you understand the amended charge now before this court and the maximum penalty that could be given to you upon conviction of that charge? You also heard what the state is recommending as far as the state's recommendation in this matter. Is that what you understand to be the state's recommendation under the circumstances of this charge now before the court? Do you also understand that even though the state has given this court a certain recommendation, I'm not bound by their recommendation. I certainly will consider it. I'll consider what you and Ms. McCandless have to say, but bottom line, I'm not bound by what any of you have to say, interestingly. And this court is free to give you whatever it feels to be the appropriate sentence up to the maximum that I just went over with you. Do you understand that? Do you also understand that if you are not a citizen of this country and upon a finding of guilt by this court for this amended offense, that you could be deported, denied admission, or denied naturalization to this country should federal law be applicable in your particular circumstances? Do you understand this as well? Do you also understand that in order for the state to prevail in this matter, they must be in a position to prove up their case beyond a reasonable doubt? And they do so by proving up elements of the offense to which you're pleading to today. Has counsel gone over with you and explained to you the elements the state would have to prove up beyond a reasonable doubt in this particular matter? And Ms. McCandless, I don't know if you filed anything like that with us in view of the fact that this was an amended plea.
I did, Your Honor, and I actually have hard copies here that I can share with the court.
Okay, I see that 1479. Thank you very much. Thanks, Jim. All right, I have it now before me. Apparently, there has been a filing of a robbery by use of threat or force of 1479 Wisconsin jury instruction, and it appears that that is the form that she went over with you. Is that right, Mr. Jones? Did you understand each and every one of those elements that were set forth in that jury instruction and explained to you by Ms. McCandless? Let's go ahead and incorporate those legalistic terms, elements to the factual aspects of this case, which are going to have to be proved in this particular matter. Let me get that real quick. All right, in this case here then, pardon me, I just got one, I clicked one extra click.
There's hard copies. There's hard copies of the jury instructions with the papers I just handed.
Yeah, I understand. I have them, but I want to go over the facts to incorporate those elements. In this case here, the state would have to prove that you did on September 5, 2016 at 1042 West Silver Spring Drive in the city and county of Milwaukee, state of Wisconsin, that you, with the intent to steal, did take property from the person of SSJ, the owner thereof, by threatening the imminent use of force against the person of the owner, with the intent thereby to compel the city owner to acquiesce, big word meaning to give into the taking or carrying away of said property, all contrary to section 943.32, sub 1, sub B, and section 939.50, sub 3, sub E of our statute. Do you understand that, sir, the element the state would have to prove up in this particular case? And have you, your attorney, had a chance to discuss this case thoroughly? And do you understand all of the possible defenses, strategies, or tactics that might be utilized to defend against the count now before this court? And based upon all those factors and considerations, then, sir, what is your plea to the amended count of robbery by threat of force now before this court? All right, please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God, in the matter now before this court? That's your right hand. You put your, you had a 50% chance of being right there. I want you to know that. You're right now. You match my. All right, I got you. You solemnly swear to tell the truth, then, sir? All right, got you. All right, that said, I'm looking at the guilty questionnaire waiver of rights document, and I see your signature on that document, and again on the addendum document in this particular matter. Is that true? And prior to signing the those documents, did you read them? Did your attorney also read them to you and go over them with you and explain to you each and every paragraph in each of those documents? And did you understand each document, each paragraph in those documents as she explained it to you? And she also go over with you and explain to you the constitutional rights that you're giving up here today by pleading guilty to the offense now before this court. Did you understand those constitutional rights as she explained them? Let's go over those. You understand you're giving up your right to remain silent, not to incriminate yourself here today. You also understand you're giving up the right to compel others to come before the court and give evidence and testimony in your behalf. You also understand you're giving up the personal right to get up on the stand and give evidence and testimony in your own defense. You also understand that you're giving up the right to see, cross-examine, and ask questions of the state's witnesses who happen to be your accusers on the count before this court. You also understand that you're giving up the right to have a trial by jury in this matter, and that before you could be found guilty of the offense now before this court, all 12 jurors here in this case would have to unanimously agree on the verdict of guilty before you could be so found. Do you understand you're giving up that right here today? Do you also understand that you're giving up the right of requiring the state to prove up each and every element of the offense charge beyond a reasonable doubt? And is your plea to the count now before this court being made today freely, voluntarily, intelligently, and with full understanding on your part? Have you had any drugs, medication, or alcohol prior to coming to court here today? And are you guilty of this stranded count because you are guilty? All right, Mr. Canvas, you had a chance of going over the guilty plea questionnaire and waiver of rights document, the addendum document, and Wisconsin Jail Jury Instruction 1479 with your client to be here today.
Yes.
Are you satisfied that he understands the contents of each of those referred to documents by virtue of your explanation of saying to him?
Yes, Your Honor.
Are you satisfied as well that he understands or that he understands the nature of the charges in this matter, the elements of the offense, as well as the maximum penalties and constitutional rights that are being given up here today by virtue of his guilty plea in this matter? And are you satisfied that his plea is in fact being made here today freely, voluntarily, intelligently, and with full understanding on his part based upon the totality of your interaction with him.
Yes,
And based upon all the circumstances, then you believe there's an adequate factual basis to allow this court to accept your client's plea here today.
yes.
Thank you. State consent to the jury waiver.
Yes.
The court will approve as well. The court will find here today that the plea in this matter is being made freely, voluntarily, intelligently, and with full understanding of the nature of the charges, the maximum possible penalties involved upon conviction, the elements of the offenses being pled to, and the rights that are being given up here today by pleading guilty, and the court will accept that plea. May the court then use the facts as set forth in the criminal complaint as amended by the amended information now of record in order to establish a factual basis in this matter, Ms. McCandless.
Yes, Your Honor.
And Mr. Jones, you've had a chance to read the original initial criminal complaint in this case, right? And you understand that the amended charge now before the court, true? May the court use the combination of facts in the criminal complaint as well as now the amended charge under the amended information in order to establish that there is a factual basis to allow this court to be in a position to accept your plea here today. Thank you. The court will find that there is a factual basis for the purpose of acceptance of the plea. And based upon the plea of guilty, the court will now find you guilty of the offense of robbery by threat of use of force in the manner and form as set forth in the criminal complaint as amended by the amended information now of record. And I will adjudge you so convicted of that offense on this date and order a judgment of conviction entered upon the record. In so doing, I must tell you several things. First of all, you are now a convicted felon. As such, you may never again for the rest of your entire life ever possess a firearm. Do you understand that admonition about not being able to possess a firearm? You should also be aware that until such time as the sentence this court will be giving you is completed in its entirety, your right to vote in this country is hereby suspended, and that right will not be returned to you until such time as the sentence this court gives you is completed in its entirety and your civil rights are restored. Do you understand that, sir? All right. The court has been made aware that the state is requesting a pre-sentence investigation. Any objection to that?
No, Your Honor.
The court will order a pre-sentence investigation in this matter. What's the timetable for PSI for out of custody people?
Well, I think,
About 6 or 8 weeks.
yeah, at least that.
I think there's a form you have to fill out for that too. Probably at the end of October. No. Remember, it's the 3rd.
One moment, please. Either day is fine.
Court date, November 3rd. At 2:30 for sentencing. That will be 35 minutes.
All right, thank you very much. Cooperating fully with this PSI. She's gonna do that order on the PSI. Why don't you wait a few minutes, Mr. McCandless, so he gets that. And as far as you cooperate with Jones with the PSI writer, he can what they have to say is important. The court considers that along with what you and Mr. McCandless have to say, along with what the state has to say. Okay. All right. That was great. Thank you.
And I've got one other case, but I think we need to get another date on that case.
So hang on just a second, just stick for just for a minute.
Did you want to go first? Who do you want me to get on the line? All right. Let's go, Amanda Parent. Let's do that. Ms. Parent? He's not responding. I'm going to Jeff Schwartz and ask him to unmute.
Hi, Judge.
Hi, Mr. Schwartz. How are you doing?
Long time no see.
There you go. What's your client's name?
Ashley Coleman.
Okay, hang on. Okay, calling the case of State of Wisconsin versus Ashley Coleman, 18 CF 1464. Also, State of Wisconsin versus Ashley Coleman, 14 CM 3008.
Stephen Glam appears on behalf of the state.
Jeff Schwartz appears on behalf of Ashley Coleman. I appear by Zoom.
All right, thank you. Any objections to appearance by the Zoom protocol, State?
No.
Defense?
No.
And where's Ms. Coleman, by the way?
Judge, I haven't been able to recently get in contact with her this week, but I have stayed in contact with her all summer. So I would just ask for a stayed warrant. She has called me. The problem is she doesn't have a cell phone. She has a landline. So I haven't been able to get in touch with her like in the past couple of days, but she has kept in touch with me all summer.
Do you have any objection to that?
No.
Well, so what are you going to want to do with the case? Do you know?
I would just ask for another scheduling date.
So what can we do for him in that regard? Yeah, she can use her landline to call into the Zoom, but doesn't have to have a mobile line.
So you said September 9th?
September 9th at what time? 8:30.
That's fine.
All right, you have her call in. I'm going to issue a bench warrant today, however. I'll stay until September 9th at 8:30 to give you a chance to get her back on track here. And then we'll go from there. Okay?
Thank you very much. I appreciate it.
All right, thank you. Nice seeing you.
Nice seeing you.
You bet. I'm going to call Amanda Garrett again and seeking her to unmute. She remains, oh, here she comes. Good.
About that, Judge.
Garrett? Garrett.
Yes, good morning.
Okay, very good. What is your client's name?
Vincent Harrell.
Great, thank you. Case 20 CF 1744, State versus Vincent Harrell. Appearances, please.
Stephen Glam appears on behalf of the state.
Amanda Parent on behalf of Mr. Harrell, who is in custody and not produced. I'd ask the court to waive his appearance. Good morning.
Good morning, ma'am. All right, where is he in custody, by the way?
He's at the House of Correction.
All right, what do you want to do with this case?
Your Honor, this is our first date in front of the court out of prelim. I am still working through the discovery. If the court would allow one more scheduling date, I would request that, please.
All right, one more until we go ahead and then you tell me what you want to do as far as plea or trial. And let's just we'll try to keep this thing going for you. That's all I can tell you. Okay, go ahead there, man. By the way, they have not gotten back to me on that week of September 21. It's too bad, because we could use that.
The afternoon of September 30th or October 1st?
Afternoon or 30th or 1st.
Could we please do the afternoon of the 1st?
Sure. Next Thursday, October 1st, 1:30.
All right. Zoom and we'll go from there. Okay?
Great, thank you.
All right, thank you. And Sarah Joseph now? Okay. Hi, I'm sorry. Hi, Ms. Joseph. Right, you have Colin Gatson?
Yes, Your Honor.
All right, here we go. Calling Wisconsin versus Caroline Gatson, 19 CF 2798.
Stephen Glam appears on behalf of the state.
Sarah Joseph appears on behalf of Miss Caroline Gatson, Your Honor, who does not appear.
Yeah, where is she? What's the story with her?
Your Honor, Miss Gatson is out of custody. I have not been able to contact her, unfortunately. I don't know if the court is willing to give a new date. If so, I would take it, but I really don't have
Well,
any.
out of custody, and you haven't been in contact with her. I'm just going to issue a bench warrant. Any monies on deposit will be forfeited, so that we've got to regain this custodial situation with her. And after she gets back on bond, the better it will be for her. But otherwise, it's going to be a longer situation than she wants, and longer than we want. But let's go ahead and do it. Try to get her back under everybody's control, and we'll go from there until it's time, though. Bench warrant issued, forfeiture of monies on deposit. Thank you.
Your Honor, oh, sorry.
Yep.
I do
Go
have
ahead,
one
ma'am.
request as to the bond. Would it be possible to not forfeit that at this point? Miss Gatson, she does, sometimes when she misses, she has contacted me and told me that she's been in the hospital. I know her family members have posted this bail.
Well, let's put it this way. If such a situation exists and we bring it to our attention after that fact, the court can also reinstate the bail. But I'm not going to guess that she's in the hospital. I'm not going to guess she's got good reason for not being here. And all I know is she's not here. So until I see a good reason, the matter's in the forfeiture mode. That'll be the court order in that. Thank you.
Thank you.
You bet. All right.
I've got one last case.
We have another one? Which one?
It's Darius Williams. He's set for sentencing. He's not here. He's in compliance with Justice Campbell. He's a high school student.
Okay. On the record, we're calling the case document bench warrant. No, she has to be.
Well, I know he has to be. I'm going to ask you to stay.
We're going to call the case. I don't know what the hell her name is.
Darius Williams.
All right, Darius Williams, State of Wisconsin versus Darius Williams. 19 CF 4980. Appearances, please.
Stephen Glam appears on behalf of the state.
Victoria McCandless appears on behalf of Mr. Williams. Mr. Williams is not here. I do know that there's a Justice Point report indicating compliance and that he's employed at Burger King and is enrolled in Barack Obama High School. My mistake, Judge, was calling the young man directly and leaving a voicemail. I should have called his grandmother and his mother directly to remind him of that. But otherwise, he's been in really good touch with me. I'm asking the court to stay a warrant and reset the sentencing date. There was a pre-sentence done here, and I've gone over that with him.
You missed before?
No.
I won't object, assuming we can get a date pretty quick. If anything, just to make sure he gets here. Maybe we wouldn't be.
No, I understand, but we'll see. We obviously have limitations in that regard too. But let's go. What can we do for him? Yeah.
Of what?
September 9th in AM.
No, I can't do that. I've got 2 Zoom appearances already set.
see it doesn't bother the court is already jammed up. We have 1, 2, 3, 4 days that are up in September.
Is it, would, Ms. McCandless, would it work just for a status date on the 9th to make sure we're in touch with him?
Here's the problem, I can't be doing Zoom and be down.
Oh, yeah.
Afternoon, the 16th or
Again, okay, so 17th, I'm already here at 1:30, so that's fine.
What date?
September 17th.
Okay, September 17th at 1:30. I'm gonna put it down for sentencing. And hang on now. That's fine. I will issue an expense warrant, but I'll stay in until 1:30 on September 17th. And together here, we get this, we want to get this done. Everyone I get done, I don't have to see again. And you know, that's the whole point, but that's why I'm doing this. But this is why
I'll make sure this time I call his grandmother and his mother.
Thank you, Miss McCandless.
Thank you, Ms. McCandless.
I hope so, because that's it. You guys gotta go to lunch.
That's the stuff that we didn't do on the calendar. It turns out I spent my morning emailing attorneys, and the clerk in here had another clerk for 30 cases yesterday. So that's that.
We can only do what we can do. So we can. Everyone must be busting their tail to do it, and it's not a question of anyone trying to blow it off.
No. They were just being sneaky.
I
don't know what. Why did I think that if I left a voicemail message for a teenager that would be, you know, something?
Yeah.
You know?
All right, you guys. Thanks for getting that set up for the Zoom thing, and I'll get one more done. Thanks, Steve.
Oh, thank you for being patient.